Good evening, ladies and gentlemen. Welcome to the May 9th, 2024 meeting of the City of Gloucester Zoning Board of Appeals. This meeting is being held as a hybrid meeting in person here at City Hall, 23 Dale Ave, and also available in a Zoom setting on Zoom meeting ID 840-8069-3208. I recognize in attendance myself, Joe Parisi, Peter Canavo, Ronald Wilson, and on Zooming in, Catherine Schlichty. And we have 4 members present. I declare a quorum. The first order of business is the approval of minutes of April 25th, 2024. And no corrections or omissions. I'll take a motion to approve.
I make a motion for April 25th.
Second.
Made and seconded. Roll call.
Mr. Wilson?
Yes.
Mr. Canavo?
Yes.
Ms. Schlichty?
yes,
Mr. Parisi?
Yes. So tonight we have 3 continued applications. The first is the petitioner of Iberian Trading Corporation, seeking a special permit under 2.3-3 and 1.9 in variance from side setback requirements 1.7 to construct a deck on a pre-existing non-conforming structure at 21 Horton Street. Attorney Ellison.
Mr. Chairman, thank you for the record. Deborah Ellison, Ellison Law Office, 63 Middle Street, Gloucester. I have a question with regard to a point of order at this, before we begin. My notes state that Mr. Wilson was present at the last hearing, but I don't know whether he was a voting member at that point and whether that matters at this time.
So he was in attendance,
He was.
participating. He wasn't voting on it at that point, but because we had enough people, he's an alternate.
Okay.
He is able to participate and vote here.
Okay, thank you. I just wanted to clarify that. When we left here the last time, my client's Iberian Trading Company, President Claudia Kittredge, she is on the line along with Vincent Navarro. The property, as you may remember, is at 21 Horton Street. And when we left the last time, there was a question that the board raised with regard to whether it was illegal for the board to grant a special permit when a portion of the accessory building encroaches into a private way. I filed a motion memo with the board, and we were not able to find any cases that indicated that it was illegal for the board to issue this permit in these circumstances, and neither did Attorney Favazza. He was only able to provide you with cases related to the very limited exception to the general rule. And the default position of the courts for many years has been that that the city should not get involved in adjudicating private property rights. The Brady case that was cited by Attorney Favazza is the exception to the rule. It's clearly different from the case at hand. It involved a subdivision where the law owners owned a parcel of land on the shoreline in common. It was a subdivision, and one member of the subdivision wanted to put up a patio. And there were other people in that subdivision who did not want that to happen. The court decided that was a very unique situation, and in that case, it was appropriate for the city to question the ownership. Here we have a building that's been in the same location for approximately 70 years, according to the assessor's records. We have a private street that has numerous encroachments on it. The new deck will be entirely on the applicant's property. No part of the existing building is moving or being reconstructed, and there will not be any further encroachments into the private way. And currently, the cottage is at least 1 car length away from the paved part of the way. Therefore, it doesn't block the traveled way. The neighbors have if the neighbors have a problem with the building that has been in the road layout for 70 years, then their recourse is the courts, not the zoning board. It's not like the Dennison case that Attorney Favazza pointed out. In that case, city property was involved. It was a public way. This is entirely a private matter. In the Corey case, it's also distinguishable in that they were putting up an entirely new structure in the private way. We clearly don't have that situation here. It's a slippery slope, I would suggest, if you follow Attorney Favazza's line of reasoning. That would require you to adjudicate all manner of private ownership disputes involving encroachments in the private way. Certainly not a unique situation in Gloucester. It's not even unique on Horton Street. That's not your role, and the courts have supported that position time and time again. In only the very narrowest of circumstances, the court held that the city could deny a permit based on private ownership. Lastly, with regard to Attorney Favaza's argument stating that there are other permits required before the applicant can and construct the deck, I would point out that they did have a building permit and an occupancy permit for the building, and that the neighbors had other avenues of appeal that they did not take advantage of. And that issue is not before the board tonight, and it's irrelevant to the special permit. So I would again ask that you grant the special permit for all the reasons that we cited previously, and I'd be happy to go through them again if you would like. Thank you.
So we've also been working with our attorney, trying to get some clarity. And many of the points raised deal with the fact that because the structure is not on the lot, it never was conforming to zoning from 1921. That to be able to meet the criteria to grant the special permit requires measurements, dimensional things. And there's no way to calculate things like lot coverage when the building's not completely on the property. This is the advice we've been given. And that although the building can stay there and they can maintain it and whatever they want, that we should not be granting an increase in its size when it's not on the lot. It never was on a lot that was legal, so it didn't become non-conforming that would allow it to qualify for an alter and expansion of a non-conforming structure. So I'm not, and we're back to differences of opinion, and I guess I'm leaning toward the city solicitor's opinion as telling us that we we shouldn't be granting an expansion of a structure that's not on the lot. That's where I've been back and forth at getting advice for the last couple of weeks. And that's what's been told. So I'd be interested to ask Catherine what she thinks. Did you get the memo?
I did. I thought that Deb made a good point in the memo that because it's a private road, state statute grants, private ways, owners own to the middle of private ways. So are they exceeding their property use rights when under state statute, they, unless a subdivision owner specifically keeps that right in those ways, then each property on either side of the road owns to the middle of the road. So I don't know, Deb, maybe if you can speak about that a little bit.
Certainly. Through you, Mr. Chairman, the statute that Catherine is referring to is the derelict fee statute. And unless the developer, however many years ago this was developed, reserved the fee in the road, then that goes to the abutters. So each abutter would own to the middle of the road. And that was an issue that came up previously before this board, where the board did determine that a building that was currently in the road was going to be torn down and rebuilt and was allowed to be built within the private way. I would also suggest that with a building that has been there for over 70 years, there are certainly potential adverse possession rights. And those are things that can only be determined by a court. It's not something that the ZBA should be weighing into. And as I said, I think it will raise an awful lot of issues going forward if this board decides to start weighing in on every encroachment that comes before it. It makes it, puts you in a position of trying to be judges and the court. And many times those sorts of situations are very fact dependent and take a lot of litigation to sort out.
We definitely are not attempting to decide private property rights at all. The argument is that you're not meeting the criteria for an application for this special permit. Let me read you what I've been going back today on. So, structure not entitled to pre-existing non-conforming protection. As we discussed, this application for a special permit to increase a pre-existing non-conforming structure is challenging because the structure is not located on a lot and thus in all likelihood never complied with zoning. The deed references a 1936 plan showing the lot. Although the single-family home is shown on the lot, the studio is not. Thus, I assume it was built after 1936. Gloucester adopted its zoning ordinance in 1927. Therefore, a building permit was required to build structures and plans showing the lot and structure were required for a permit. Because this studio is located partially in the right-of-way and half on a lot, the structure could never have been compliant with the zoning ordinance, and thus its protection as a pre-existing structure is questionable. Additionally, because it's not located on a lot, whether it complies with lot area, setbacks, lot coverage, cannot be determined since there are no lot lines from which it can be measured. The argument that the expansion will not impact the lot coverage is questionable because lot coverage, among other dimensional requirements, cannot be calculated. The current zoning ordinance requires all applicants for a special permit be accompanied by a site plan showing the structure as located on a lot, the dimensions of the lot, etc. This is a submittal requirement. The inability to locate the studio on the lot because it sits partially in the right-of-way presumably means that no relief to construct or expand the structure can be granted. That's the opinion we received.
And were there cases cited to support that?
No, not in this memo.
I think it's an interesting argument, but I don't believe that it's ever been set forth by this board previously. I think with regard to if the deck were being added or the building itself were being expanded, then it may be questionable. But because the deck is wholly on the lot, then I think that that argument definitely leaves some question. And there are also a lot of facts with regard to this building and how it came to exist that we don't have. The building file doesn't have all of the information that we would need to know whether or not variances may have been granted at the time it constructed. We don't really know.
You're asking for relief, which without any of that information, how do we grant?
Um,
Any thoughts?
well, I'm just, I hate to go against Suzanne. I'm sorry I did not see Suzanne's memo to you prior to this meeting because on the one hand, we don't want to resolve private property disputes. It's not our job to resolve. And I know that there was a shed. I mean, we've done sheds that were on right-of-ways and backyards and say, well, you know, because the right-of-way was wholly on that person's property, right? And they were partly going into the right-of-way that they had granted to somebody else on their property. This is a little bit different. It's coming into a private way that's, you know, other people have the right, are utilizing that to go, you know, back and forth on. So, but again, you have a building that's been there for 50 years, right? And the deck is on the non-street side of it. I'm a little torn about that. I mean, but I hadn't thought about that. You can't really make your calculations if your buildings aren't on the lot, right? We don't know what the lot coverage is because kind of a sizable portion of this building is in the right of way. So we
The other
can't get
thing that-
calculations like lot coverage. So I hadn't thought about that either. So I think that that is a interesting point that the city solicitor raises, you know, to say you
Well, there-
can't really meet the requirements.
There is a plan that was accompanied in the file
Yeah,
of the road and the lots. And the lots had front lines that were not part of the road. This was all owned by Wanson's, the paint factory people.
yeah,
And the lots were divided, but the road was its own entity, a lot, I guess to say, because there are lot lines back from the road that was drawn in. So it wasn't like everybody was, if their lot lines were down the middle of the road, that would be one thing, but that's not on this plan, nor on one we dug up to try to figure this out.
Mr.
That's the
Chair,
one that struck me. Go ahead.
if I could just point out that under the derelict fee statute, it addresses those exact situations. So if your lot line is by the road, then you automatically own to the middle unless somebody else reserved that.
yeah. I mean, honestly, you know, under every other standard, it's fine. They're expanding the deck on the non-road side of the house a few feet. It's, you know, it's pretty tight down there right now anyway. And even if the building that is in question was built without a permit, there's a 10-year statute of limitation to make, you know, it gets grandfathered in anyway if it's not brought to the, you know, the city doesn't do an enforcement action against a build in 10 years. So, you know, this has been there for far longer than that. I do think that under the derelict fee statute, it is part of their land, even if it's not part of the deed of the law, it's land that they have a use to. I mean, if they were building a whole new house, I'd feel a little bit differently. This is a deck off the back that's being expanded by what, a few feet, you know, a few feet. So. But again, it's always never a good idea to go against advice of counsel.
Yeah, well, let's, where did we leave off? We began the public hearing and then there was some questions. So I guess
I don't think you closed the public hearing, did you?
no, we didn't. And so I guess we're still in question and answer here. I would like to hear from, because he also submitted a memorandum, a legal memorandum, so maybe I'd like to ask Attorney Favazza to weigh in on his memorandum to help us get a better understanding.
Thank you, Mr. Chair. For the record, Joel Favazza, Seaside Legal Solutions, 123 Main Street, on behalf of the Britons, who are the trustee owners of the abutting property. I appreciate you taking the time to review the memo that we had sent over. And so essentially, you know, the argument that I've been listening to tonight, in either direction, the requirement is to deny this. Either A, you take Attorney Egan's advice, and she says, you know, basically, pre-existing non-conforming says that at some point it was conforming and then lost that status due to a zoning change. That's what pre-existing non-conforming is, or it predates zoning, period. And therefore, when zoning came in and made it non-conforming, it was pre-existing. As Attorney Egan has pointed out, this building does not predate zoning, so zoning existed when this building was constructed. And when it was constructed, it was not constructed on the lot, so therefore it was never conforming and cannot now be a pre-existing non-conforming structure. Secondly, if you go into what the vice chair just said, that 10-year statute does not make anything conforming. It prohibits enforcement. So if I build something with a building permit too close to a lot line, actually the building permit is 6 years, so I get no building permit. I just sneak in an addition next to a lot line. It's too close via the setbacks. 10 years goes by, You can't enforce against me. I'm scot-free in that regard, but it does not make that addition pre-existing non-conforming. It is an illegal addition that is beyond enforcement and it is not ripe for or accessible to a special permit to alter or expand later on. So even if the structure is beyond enforcement, and I would agree with Attorney Egan and Catherine that it does not make it a pre-existing non-conforming structure. And if it's not one of those, you can't grant a permit to alter and expand. On the flip side, if you say, hey, listen, we're going to go with a derelict fee statute here, and that opens up a whole can of worms because I'll be before you with undersized lots saying, I want you to count all the lot area inside the road also so I can get to, conforming lots going forward if we're going to count derelict fee statute area as qualifying lot area for dimensional requirements. But if you do that, that's fine. Then it knocks you into the Brady case that's in my memo because now you have under this hypothetical where you say, we're going to go derelict fee statute, the lot goes to the middle of the road, and therefore the entire building is on the property. That part of the property that half the building is on is subject to private property rights of other neighbors. And the Brady case is clear that you can't adjudicate those private property rights. And by you permitting the alteration and expansion of a structure that sits, even if it's within the property, in a portion subject to private property rights, you're right inside the Brady case in my memo, and you're doing what you can't do, which is adjudicating private property rights. So if you want to call the lot stopping at the lot line, then Attorney Egan has given you your answer. If you want to go the other way and say that the derelict fee statute lets you consider the entire area within the layout of the roadway as part of the lot, so it's quote unquote on the lot, then the Brady case controls. In either case, you cannot grant this permit. The last point I'll make, because I mentioned it in my memo, is again, I find it surprising that when other zoning deficiencies have been pointed out to this board, that the answer hasn't been, well, stop, we're not going to allow the alteration or expansion of a structure that is otherwise impermissible. And that goes back to the fact that it's listed as an ADU, despite the owner not living in either of the two units. So, I'm surprised here that's not a dead stop, but I would like to reiterate that again, if you go forward granting a permit like this, regardless of the other arguments, you're basically looking past blatant zoning violations and saying, well, we're the zoning board of appeals, but we're not going to talk about those zoning violations. We're just going to talk about the deck as if the deck is totally separate from the ongoing violation of the zoning ordinance. Thank you for the time.
Thank you.
I think what the board also has to consider is that this is going to be an issue that's going to come before you again and again and again. So essentially what Attorney Favazza and the city solicitor is suggesting is that if you have any of these buildings that encroach into the right of way, you're no longer going to be able to get a permit to fix it. So we're going to end up with a lot of buildings that are,
That's not what we said. You can fix and maintain a building, you can't expand it if it's not on the lot. That's what the recommendation was, and that's what I said. You can still fix and maintain your property, you just can't make it bigger.
okay? And the other argument with regard to, we're not making it bigger per se, this is an accessory to it. So the footprint of the building itself is not changing at all. And what is being added is a deck that will be completely on the property. So it is a little bit different than changing or expanding the actual building. And with regard to this not being an ADU because they don't live in either portion, they just purchased the property, so they're doing work on it. So they will intend to live in the main house, and then the ADU will also be used. It will not be, they both won't be rented, if that's what Attorney Favazza is trying to imply. And if you were trying to determine lot coverage, et cetera, and all of those types of things, you certainly can still do that. Clearly, there's lot coverage of part of the building on the lot, and I think that it creates a lot of issues going forward if the board makes the decision that you cannot alter or expand or add an accessory to a building.
Personally, I think it's logical. How can we tell you it's okay to expand something that's not even on your property? We're
And
almost like condoning violation. I know we're a relief board, but we would be saying it's okay to expand a building not on your property, or not completely on your property. I don't know, I've listened to all the different sides. It wasn't something I thought was going to come up until it was pointed out about the location. Because when you certainly look at it, it don't look like it's in the road. It doesn't, you know, it did, when I did my site visit, it didn't send me down this path that I definitely didn't want to go down. But unfortunately, I have to just try to comply with the law or what we're being told.
Yeah.
Other discussion, Catherine?
Um, I'm sympathetic to these owners wanting to expand their deck. But weighing all the pros and cons and in consideration of Suzanne Egan's memo, in general, it's just bad practice to give further relief for a building that has zoning, clear zoning violations. So I think weighing everything, I mean, I do think the private road argument has some weight, but I think weighing everything, I think I would gonna fall on the side of not being favorable to the relief requested.
Go ahead, Helen, you have something?
A thought relative to the idea that if we follow the recommendation and say you can't expand or alter a building of this nature, is there any way to make that building fall within regulations? To me, I would follow the recommendation of the city attorney. I would be afraid that we would be anointing this property in some way as acceptable, and I'm inclined to not want to touch it. But if, as you have proposed, this creates an impediment to people, is there another way for people to cure a building of this nature?
I think the only cure in light of the city solicitor's opinion would be to, chop the building up and make it smaller. And in this case, it's very small to begin with. So I think it would be more of an issue in light of her opinion if we were adding to the building on the other side, on the road side, but where nothing is getting worse than the situation that has been there for 70 years, I think that it is certainly a reasonable position for the board to take that a accessory area can be added to the deck or added to the structure.
So I think there's enough questions that easily prevents us from being able to make that decision. This is legal 4 or 5 layers of an onion here that is probably better decided by judges in the land court than it is at a zoning board of appeals made up of a plumber, 2 firemen, and a carpenter. I think there's enough question in our minds not to be comfortable to approve it, and there's always the remedy of appeal. Not that we try to encourage that, push that, but I can't see going against what we're being told from the advice we're getting from our legal representative. So. Now, we had for and against, so I think, and we had just asked to come back to look into it further. So I think we could close the public hearing if everyone's in agreement. And
Yeah.
we can make a motion to approve. It has to be a positive motion, but there's only 4, and any vote not to approve would deny it. So
I'll make a motion, Mr. Chair, if you'd like. On the petition of Iberian Trading Corporation seeking a special permit and to alter and expand a non-conforming structure and a variance from a side yard setback requirements to enable the petitioner to construct a deck on the pre-existing non-conforming structure at 21 Horton Street. I move approval.
Second.
Motion made and seconded to approve the special permit and variance. Roll call vote.
Mr. Excuse me, Mr. Canavo,
No.
Ms. Schlichty,
No.
Mr. Wilson,
No.
Mr. Parisi.
No. You heard our decisions in the negative. I'll have the city solicitor draft.
Okay, yeah, it's a very good idea.
Thank you. Okay, our next continued hearing is the petition of Sleepy Dog Properties, seeking a special permit to alter or expand a non-conforming residence on a non-conforming lot under 1.9 and variances pursuant to 3.2.1 for lot coverage and rear setbacks at 9 Bale Lane. And
Hello, Mr. Chairman. This is Derek Tyler. I live at 144 Weld Street in West Roxbury, Massachusetts. I had the continued hearing here for request for the some of the abutters to weigh in on their approval or denial of the proposed addition. We did submit 3 separate approval letters from the direct abutters. The neighbors at 7 Bale Lane, 11 Bale Lane, which is on either side of the client's side at 9 Bale, and also the direct abutter on 16 Sleepy Hollow Road, which is the direct property attaching to the backside of 9 Bale Lane. All 3 were in favor of the addition and the request, and it is our request to seek approvals for this proposed addition.
I can't hear you, Joe.
Yeah, I'm sorry, Joe. Not
Sorry,
able.
I had the mic up in the air. So the special permit, alter and expand, we know the bar for that, but could you just touch on the variances for rear yard setback and lot coverage and what makes them be required?
Yes, it was noted that the rear yard setback is 20 feet, and the current portion of the existing home is 14.4 feet. So that is within the beyond that rear setback, and we are hoping to continue that line to coincide where there was an existing deck. We are hoping to take that plot of land that has a rear deck and basically make it a habitable space, so that we thought that would trigger into the request for variance. But if the board feels as though that a special permit would be allowed, that's totally fine as well.
Yeah, so the question, I mean, you're still following the non-conforming line, correct?
Correct.
You're not encroaching any further into the setback.
Correct.
And that was with regard to the rear yard.
Yeah,
And the
and
other
the
was
side though, yeah.
The side yard.
coverage, wasn't it?
Yes, and then the lot coverage allowable was on this space was 25%. The current building size is at 36.6, and we were requesting up to the 45.2.
And the bulk of this expansion, as we've already pointed out, falls on that existing deck that's going away, and you're
Correct.
building that story up on it, yeah. Okay.
Joe, nice question. So when you calculate lot coverage, decks are not included for lot coverage calculations? That's why this is increasing the coverage, because even though the deck was there, you don't count that in lot coverage calculation, but obviously a structure you do.
Yeah, it's becoming a structure with a deck above it. And
Okay.
so that adds to the lot coverage calculation, yeah. Okay, I think we understand the project. Let's go to public testimony. Is there anyone wishing to speak in favor of the application? Anyone in favor? If you're in the hall, come forward. If you're online, can you see the participants? I lost mine. Is there anyone wishing to speak in favor? Please raise your hand on your device, or if you're on a phone, you dial *9. No one? Is there anyone wishing to speak in opposition to the application? Any opposition? Come forward or raise your hand on your device. Seeing none, looks like you've touched base with all the neighbors.
Mhm.
Because we did not receive any additional letters or anything other than the positive ones. So that's good. I'm glad you took the time to do that.
Of course, thank you for offering the time.
Any discussion by the board?
For me, the abutters letters were really important, because well, I think the project is fine and it's good. You know, I listened to the March 14th hearing, and like the other members, it's a lot of lot coverage. But the fact that those immediately around this piece of property don't have a problem with it gives me a lot of comfort, and I feel fine voting for this.
That makes the decision a lot easier, knowing that you get support. from the
Pretty
group.
well fenced area too. You get that
Right.
back line fence that
Yeah.
everybody kind of does their own thing. That was good. All right, if no further discussion, we'll entertain a motion.
Peter, you're gonna have to do it. I don't have this on my agenda, 9. Oh, I could do it off the
If you
application.
have it, you can just help me
Go
through
ahead. Yep.
Okay.
the hardship on the variance. I was still trying to. On the petitioner's Sleepy Dog property, seeking special permit to alter or expand a non-conforming residence on a non-conforming lot pursuant to GZO 1.9 and variance pursuant to GZO 1.7 and 3.21 for lot coverage and rear setback at 9 Bay Lane. Understanding the hardship, they're not encroaching on they're not encroaching on a non-conforming lot line, is that correct?
Not increasing the
They're not increasing
non-conformity.
non-conformity. Chip.
Well, so on the alter and expand, the special permit, the criteria is substantially more detrimental to the neighborhood, which is.
I don't believe it's more substantially more detrimental to the neighborhood.
And I'd like to include the variance only because out of caution. I'm not sure it's needed, but I don't want them to have to, somebody raise it and come back. So I think the lot coverage, although he's not covering any more lot, the hardship would be that it counts different. And we could include that. So,
Thank you.
so that's your motion?
That is my motion.
I will second that.
Made and seconded for a special permit to alter and expand and a variance for rear lot coverage and rear setback. Roll call vote.
Ms. Schlichty,
Yes for the special permit and yes for the variance.
Mr. Canavo,
Yes for both.
Mr. Wilson,
Yes, for both.
Mr. Parisi.
Yes. Heard our decision's favorable. we will, unless you have an attorney, we will draft a decision and get that out to you as soon as possible.
That's perfect. Thank you so much.
Okay, our last continued hearing of the night, and our last hearing in general, is the petition of Elizabeth Akeley seeking a variance under 1.7 and 3.2.1 from dimensional requirements for lot frontage at 11 Walker Court. Adrian?
Rita Cahoon is raising their hand.
Oh,
What's the first name? Bridget?
Good evening, Mr. Chairman, members of the board. Good to see everyone. Adria Pratt with offices at 85 Eastern Avenue in Gloucester. I represent the Akerley family with their petition at 11 Walker Court. I have had, based on the last couple of meetings regarding this application, I have had conversations with the attorney for the city, Suzanne Egan, and it was her recommendation at this point to move on to the planning board and submit a request, an application for a roadway improvement plan. And so at this time, the applicant would like to withdraw his application before the zoning board without prejudice.
Ready? We'll need a motion to accept the withdrawal.
I would move to accept the withdrawal request without, I would move to withdraw without prejudice the application for 11 Walker Court.
Second.
We have a motion made and seconded to accept the withdrawal without prejudice of 11 Walker Court. Roll call vote.
Mr. Canavo?
Yes.
Ms. Schlichty?
Yes.
Mr. Wilson?
Yes.
Mr. Parisi?
Yes. Okay, good luck with the planning board.
Yeah, I think that's the way to go. We can't.
Thank you
get-
very much.
All right,
Appreciate it. Have a good night, everyone.
night.
Okay, folks, those
I
are the
said
only
that was-
hearings we have tonight. Our next meeting is May 29th, 30th?
30th.
May 30th. And we do have applications coming in for that. And we also have the continued application of Plum Court, 12 to 18 Plum Court. That's that night too, so if anybody hasn't,
Heard that.
I don't even know if we
Is it a new application? We did open that hearing.
opened the hearing, but there was request to continue because a lot of opposition, letters
Yeah.
that came in. So he had just asked to continue right away. So I don't think.
Okay, there
anybody-
was no testimony taken or
Yeah,
anything.
no,
Okay.
so I think whoever's here on that will be eligible.
Did he even start making a presentation?
No, you asked to continue because
Right.
based on what we received for letters from the neighbors.
So we're still in the batter's box.
Yeah,
Everybody's eligible.
there are a lot of letters there from, abutters, neighbors who in opposition, so.
I think we'll see if they're able to remedy that. I'm sure there'll be people to testify one way or the other. And then we have new applications, so it'll be good, get back. I know James is flying back today, and Michael had to be at a conference, so. And Catherine Dedicated is out in California calling us.
Yeah.
We appreciate it.
It's a little earlier for me here, so it's not.
Yeah, exactly. All right, any other questions by the members? We good? Entertain a motion to adjourn.
So moved.
Second,
Motion made and seconded to adjourn, requires a roll call vote.
Mr. Wilson?
Yes.
Ms. Schlichty?
yes.
Mr. Canavo?
Yes.
Mr. Parisi?
Yes, we are adjourned. Thanks,
All
everybody.
right, nice to see you all. Have a good evening.